Welcome and thank you for joining Seyfarth's webinar. Tales from the Benches. Judges talk to clients about courtrooms, court Zooms, and counsel. All participants are in listen-only mode. You're encouraged to submit questions through the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification will be read during the presentation. Please write the code down. It will not be repeated, and it is required for your CLE credit. Please note the ethics CLE credit approval is pending, but we just learned this morning that we have professionalism credit approved. Copies of the webinar recording and materials will be distributed to attendees following the presentation. As you can see, we have our legal disclaimer, and now it is time for the program. I will serve as your moderator today, and I'm here to field your questions as they come in. My name is Rebecca Woods. I am partner with Seyfarth. I'm chair of the Atlanta Commercial Litigation Practice. I'm also co-head of the National Commercial Litigation Practice Group. And what's going on with the judiciary is top of mind for me and all of my colleagues. Now, let me introduce our esteemed panelists. First, the Honorable Judge J.P. Boulay. Judge Boulay was appointed to the U.S. District Court for the Northern District of Georgia in 2019. Prior to his federal appointment, Judge Boulay served as a judge of the DeKalb County Superior Court, where he founded the DeKalb County Veterans Treatment Court, and he's still a member of the State Bar of Georgia's Judicial Procedure and Administration Uniform Rules Committee. Next is the Honorable Judge Jane Barwick. Judge Barwick was elected to the Superior Court of Fulton County in 2015. Prior to that, she was a judicial officer and magistrate judge for the Fulton County Superior Court. She is currently an adjunct professor at Emory University School of Law. And to round out our field of current judges is the Honorable Judge Dax Lopez. Since 2010, Judge Lopez has served as a judge on the State Court of DeKalb County, where he presides over both civil and criminal matters. He's an active member of the Atlanta community, serving as past president of the Georgia Hispanic Bar Association, and he was recently appointed to the regional board of the Anti-Defamation League of the Southeast. And last but absolutely not least is my fellow partner at Seyfarth and former state court and superior court judge of Fulton County, William B. Hill Jr., or Hill as he is affectionately known. Hill started his career at the Georgia Attorney General's office, spending 13 years there, including 6 as the director of the criminal division. He was the youngest division director in the history of the Georgia Attorney General's office and the first African-American attorney to represent the state of Georgia in oral argument in the U.S. Supreme Court. He was later appointed as a judge to the State Court of Fulton County and then served on the Superior Court of Fulton County. Since his time on the bench, he's been in private practice, and we are thrilled to have him as a colleague. Hill is here to provide us a view from the other side of the bench as a former judge. Okay, so let's dive in. Let's pull up we've got our panelists, and I'm going to call on anybody who's being unduly quiet. I know you're a shy group. But the first of our topics is the burning question on many people's minds is, what's up with the court system and when will their cases be set for trial? Judge Boulay?
Sure. Well, initially, thank you so much for having me on the panel this morning. I've known Judge Hill for a long time. He's been a mentor to me, so I was very happy to get the invitation to take part. To answer your question, just to set the stage on where we've been over the last 12 or so months and where I think we're heading in the next several months, I think here in federal court, both in the Northern District of Georgia, Atlanta's division where I sit, as well as throughout the country, I think we've been able to keep moving fairly well throughout the pandemic. We have continued to have civil hearings of all types by Zoom. We've been doing criminal pleas and sentencing by Zoom when the defendant consents. When they don't, I've still had limited pleas and sentencings in court. I've even had a bench trial with some live and some remote.
No, we lost Judge Boulay. Judge Barwick or Judge Lopez?
I'd like to just say that first of all, I echo Judge Boulay's sentiments with regard to being here today and our regard for Hill. I've got a good picture to bring to you because last week in Fulton County in our Superior Court, we had our first jury trial It was obviously a criminal case, and it went extremely well, particularly for the defendant. And we consider ourselves kind of up and running. And the other thing is that we do plan civil jury trials, and we have one planned for April. They're unusual. But the irony is, and I think you will all hopefully find, that once you get past the initial differentness of where voir dire is conducted, and then all of the technology within the courtroom, and the fact that the jury's not in the jury box, they're out in the audience, it's pretty much like a regular trial. So we're very excited, and it's not going to break our log jam, but we're a little bit ahead of where we hope to be.
Judge Lopez?
Yeah, so first let me echo what everyone said about Hill. I carried Hill's briefcase for 3 years when I practiced back in the day, so I'm happy to be here. Let me echo what they've said. One, for the last 12 months, the DeKalb County Courthouse has been essentially closed to in-person proceedings. So we've had to pivot, just like everyone else, to using technology. And that wasn't an easy pivot, because not every judge was comfortable with moving towards a virtual platform. So it took us a couple of months to sort of get up and running for some. But essentially, courthouse has been essentially closed, and now we're starting to look at how can we start reopening. The problem with the emergency declaration by the Chief Justice is it sort of left it to each individual judicial circuit to make a determination as to when they would open. And so I would say DeKalb has been a little slower than most to create a plan. I think we're starting to look at the plan now. Our Chief Judge in the Superior Court has set a goal of 130 cases per 100,000, and that's sort of her threshold. She's not planning on reopening the courthouse until we hit those COVID numbers, which right now we're not necessarily close to. So, this is sort of a moving target. It depends on what the COVID numbers look like before we start opening, but there is a plan in place to open up jury trials. And essentially, we're looking to start maybe in May or June. But it'll be Superior Court only, it'll be criminal trials only. So no civil trials are going to be scheduled in the foreseeable future. I know that the folks are more concerned with speedy trial demands. They're concerned with folks who've been sitting in jail for the last 2 years, awaiting trial. And those are the cases that will take precedence as we start to open up our courts.
Judge Boulay, you got cut off, and thank you for rejoining us. We've gone through everyone else, but what else did you want to add with regard to what's happening across the court system in particular? If you have any intel, I'm sure we have clients on the line here who have matters elsewhere in federal court beyond the Northern District of Georgia.
Sure, and my apologies for the connection problems. We obviously spent a lot of time making sure everything was working, and somehow the computer systems here in the courthouse kicked me off, so my apologies to you and to everyone. As I was saying, we've had a lot keeping things going, but the big hang up, as I just heard Judge Lopez state there at the end, was our inability to have jury trials. Here in the Northern District of Georgia, we are starting jury trials up at the beginning of May, and I think we even have one judge who has a trial set for the end of April. We think we can do so safely then. We have been meeting as a court weekly and carefully watching the numbers throughout this pandemic. We were originally hopeful to ramp back up last fall and had planned to, but with the spike in case numbers, we retracted that and opted not to. But we, with our clerk now, have come up with protocols, and given the numbers, we think we can have trials and do so safely for everyone. In addition to masks, social distancing, wiping down witness seating areas and microphones after each witness, plexiglass screens in front of all speakers, counsel stay at tables as opposed to walking up to the podium. electronic evidence on screens to the maximum extent possible as opposed to hard copy evidence. HVAC units have been adjusted for maximum circulation, et cetera, et cetera. We've spent a lot of time with these procedures. We're going to do our jury selection. We're only going to have one trial a day, and that one trial starting each day, which will allow us to do jury selection in our very large ceremonial courtroom and do jury selection and still keep that social distancing. I'm actually starting my trials. I'm going to start out with civil trials where I need fewer jurors in May, and I'm going to do those in May or June. And then when we get to the summer, after we've gone through a couple and hopefully the numbers continue to reduce, then I'm going to start with my criminal trials where I need more jurors, both for jury selection and in the courtroom. I'm fortunate I don't have a huge backlog of criminal trials just yet, because the way they assign cases to new judges in this district is, although we inherit old civil cases from other judges, we start off with 0 criminal cases and we're just put on the wheel and get every 11th criminal case. So I don't have a huge backlog, but I know that a lot of courts and judges that have been around longer certainly do. I have communicated with some other judges, other federal judges throughout the country, just to get a pulse on what some other courts are doing. That's obviously something we've been monitoring throughout this process, but just in the last couple of days in preparation for this, I reached out to some other judges I know. In Indiana, they actually started jury trials back in March, both criminal and civil, and the report from the judge I spoke with there noted that the jurors felt very comfortable and they were happy with the safety measures, and they haven't had any issues. So that was certainly heartening. Another judge I spoke with in Louisiana, they are starting this month. Another judge in Pennsylvania, like us, is starting back in May. They are going to give criminal trials a priority there. They've alerted litigants that civil trials probably won't start until after Labor Day, and they're doing just one trial in the courthouse at a time, which is slightly different than what we're doing here in the Northern District, where we're only going to have one trial starting each day, but that could mean that you have multiple trials going, obviously.
Can either you, Judge Barwick or Judge Lopez, talk about what your pipelines are in terms of clearing out your criminal backlog? Because unlike Judge Boulay, you two are a little bit more seasoned and have probably a fairly fulsome criminal docket.
I certainly fall into that category, and I have 220 cases assigned to me that do not include unindicted cases. And those unindicted cases are basically every felony that has occurred in Fulton County, Georgia over the past year. So I get 1/15 of that, which I'm expecting about 100 new cases just in a day. When I open up my computer, there they will be. So it's dire. There's no hiding it. We have a plan. But I think that you've heard the Chief Justice of our state Supreme Court, Harold Milton, who has just done an unbelievable job during all of this, say that 1 year's delay equals about 3 years of catch up. And I think that's probably where we are with criminal.
On my end, so in state court, we only handle misdemeanor cases. So our volume is significant because there's a lot more misdemeanors than there are felonies. So in a typical pre-COVID month, I would dispose of between 200 to 400 cases a month. Just through pleas. I mean, a lot of those cases end up pleading. The misdemeanors, people don't do significant jail time. So we were running through a lot of pleas. But potentially 2 or 3 trials a month. I mean, there's a 1-day, 2-day trial, so you can knock them out pretty quickly. Now imagine that 200 to 300 cases stacking up over 12 months, where now there's very little incentive for a defendant to take a plea, because what we ended up doing initially is, as long as it wasn't a violent offense, we went ahead and gave you bonds, so everyone's out of jail, so no one's sitting in a jail cell awaiting trial. Very few folks. So those folks have very little incentive to take a plea at this point, and I think criminal defense lawyers rightly are telling their clients, look, it may take the court a year, 2 years, 3 years to get to your case. In that time, potentially evidence is lost, witnesses move, officers no longer work for the police department. Better sit on the case. If you don't need to plead it out now, let's not do it. And so that has ended up in creating this massive backlog. Now, I'm fairly lucky. Instead of having about 3,600 cases on a backlog, I have about 2,400. So we've managed to at least clear out about 1,200 cases over the last year, either through pleas or through through no process, dismissals by the prosecutor. They've made determinations as to cases that they're not going to prosecute, and they've dismissed a lot of cases. But it is significant. Once we get started, we're going to have to start clearing through that 2,000 plus backlog that we have in our caseload.
So we have a question that's actually apropos of this particular discussion, and the question is, are you seeing whether the business courts have capacity, and are matters being transferred from perhaps your courts to the business courts so that we can move those civil lawsuits ahead?
Okay, I'll jump in and go ahead, Judge Lopez.
No, you've got this, JP.
Okay. This is just one conversation I had, but I happened to be speaking with an attorney last week. We have a new business court in Georgia. I think that we have a lot of probably folks that are dialed in here in Georgia, but I know there's some folks outside of Georgia as well. Everyone here in Georgia know we have a new business court here in Georgia, statewide business court with Judge Walt Davis presiding there. And I actually spoke with a litigant yesterday, or not yesterday, last week rather, who was considering taking his case out of Superior Court where it was and moving it to the business court because the business court wouldn't have the same issues as the Superior Court and the state courts have. So I think that's certainly something for litigants to speak about. As I understand the rules for the Georgia statewide business court, at least at present, both sides have to consent to the either the initial filing there or the transfer there. And I understand that Judge Davis certainly has capacity in his court right now.
Hill, with regard to this pipeline issue, what are you seeing in practice? What are your clients doing with regard to this backlog? The idea of justice delayed is justice denied, or are they enjoying this delay?
It depends on for some clients, time apply, for time's a weapon. And what I'm seeing is that those clients, especially on the plaintiff's bar, if they want to move their cases quickly, they're making smart decisions about where to file their case. If they file their case in Superior Court, and generally they only go to Superior Court if they need equity relief. So they'll file it in Superior Court because they need equity relief, but there's a trade-off. And the trade-off is, as discussed by Judge Lopez and Judge Barwick, the backlog of cases, the probability of getting to trial, and a lot of these very big cases, they find these cases settle on the eve of trial because you need that extra push that comes from actually putting a jury in the box. And if you delay that push, you delay a resolution. So if you've got a plaintiff and wants to try and get a case resolved relatively quickly for his or her client, because they probably need the financial resources that come from a settlement, I think the smart thing to do is to go to state court and file your case in state court. Even with the backlog of misdemeanor cases, it's not nearly as slow a pipeline as it is in Superior Court. So what I'm seeing is the astute plaintiff's bar, they're looking to file in state court so they can move their cases a bit faster. Now, what has happened is it's turning the Superior Courts into felony disposition courts and domestic courts. And the big money civil cases where you don't need equity relief, they're going to state courts and they're turning our state court judges into business judges so that they can resolve business disputes. And that's what I'm seeing. I am surprised when I see a plaintiff's case filed in Superior Court and there's no plea for equity relief. I ask myself, why are we here?
All right. I'm sure there's much more to be discussed, and if there are any burning questions, folks can use the text box, but I want to move on to our next topic, and that is because of the pandemic, we've seen a sea change in practice, judicial, private, and all other kinds, and some has been amusing, and some has been good, and some has been less than ideal. What have you enjoyed the most, the least, and what do you think should stay post-pandemic? Judge Barwick.
I don't think there's any question, but that there have been advantages, and there for all the sadness and just disaster, there really has been a fairly bright light in what we can do remotely, particularly with civil cases. It had always been my practice to have very routine status conferences, and they were really to annoy you to death. There was absolutely no purpose other than make you come park in our nasty parking lot and make you go through security and make you come up our elevators and instruct you that it's much better to settle. Now we are able to handle those remotely, and it takes away some of that annoyance factor, but we can do it a lot more often. And I have had civil cases move so well. And I, when you ask me, I do have something to say on Hill's sword versus shield issue, but status conferences remotely will be here forever.
Very good. Judge Boulay?
I would agree with Judge Barwick. I mean, I think this pandemic has been tragic in so many ways, and I too have such sympathy for everyone who's been affected by it, both seriously and otherwise. I think many of us may have staff members with small children at home that are trying to juggle their work and their children at the same time. I mean, that other than people who've been sick, I think that's one just horrible thing about this is you've got so many people trying to juggle everything, and I think that's been hard for certain members of my staff with small children, and I know it's been hard for litigants as well. Early on in this, I was very, very liberal on extensions. And I've always, I think been pretty liberal on that. If both sides consent and need that first extension on discovery, it's a little bit different story when they get to the second or third. But as we've learned throughout this, you can still get a lot done remotely with depositions and otherwise. So I've tightened things a little bit with extensions. I mean, it's no longer acceptable to me for someone to say they need an additional 3-6 months because they haven't been able to take depositions. I think we've learned you can take depositions remotely. And I think I would argue you're better off remote, being able to see someone's face and have them see yours than trying to do it in person, sitting at a conference table, 12 feet away from each other with masks on. But that's just my personal opinion as a former advocate. People may think differently. And as far as the status conferences and things, there's so much that we can do remotely, which I think saves people a lot of time and money. I think it's Rule 1 of the federal rules, the just, speedy, and inexpensive determination of every action, right? If I have a lawyer in Augusta that's got a case here, or Bangor, Maine, for that matter, and we've got a less important hearing, not a summary judgment argument, but something less important, there's no reason we can't do those remotely, and I intend to continue to give that option for the smaller conferences and things. The one real detriment, I think, is just the lack of camaraderie that I think we've all had, and I'm sure Judge and which I think you've probably had that there at the law firm, and in-house counsel that are dialed in have probably had that in their offices as well. You really lose something when you're not seeing each other in the hallways, being able to pop into your offices and talk about things. I think that's affected. It's certainly affected my chambers, and I assume it's affected everyone. So I'm certainly looking forward to getting people, back in the office, which I hope to do next month as well.
Judge Lopez, what have you liked the most or the least, or both?
Well, let me start by saying that the children at home issue is really sort of critical. I have kids at home. I have a kindergartner at home, which has really sort of impacted my ability and my wife's ability to sort of juggle our work and life balance as we're trying to be teachers and trying to be professionals. It is hard to do that, and I know that if it's hard for us, it's hard for the folks that we serve. Anytime we ask somebody to come on a Zoom call, or anytime we schedule a hearing, we might be taking them away from something that they have to do at home with their children. Because I know my kids had to log on 5 times a day, and I was the person who had to make sure they were logging on 5 times a day. So I know that's impacted me and my chambers and my staff, and it's really sort of impacted our productivity throughout this process. But what I've liked about what's going on, I guess, with the pandemic and the virtual, is that it really has forced our court to come into the 21st century. It's really forced us to think critically about our technological needs. How can we best serve our citizens? How can we best serve our lawyers that practice in our courts? And it's really forced us to come, together to decide how can we continue to provide services throughout this pandemic. And it wasn't easy to get everybody on board. There are judges who they've been doing this for a long time, and they liked the way they did it. And come hell or high water, they weren't going to get on a Zoom call for anything. And it took those judges a little bit longer to get started, but once they started and they saw how easy and intuitive it was, they now enjoyed. I think they've now incorporated that into their daily routines. So I like the convenience, just like the other judges have mentioned, being able to set a hearing, and you can have people all over. Not necessarily here in Georgia. You can have people out of state, and we can still get business done. So I like that. My favorite part is finding out what people are wearing when they come on Zoom calls. You just never know what you're going to get on any given morning, particularly with some of our citizens in DeKalb who have just woken up and they're still in bed in their pajamas, and they've logged on to Zoom, and literally under the covers, in bed, sideways, with the phone sideways. They've not gotten up out of bed. They've got curlers in their hair. They've got, it's always interesting to see what we're going to get on any given morning when people log on. I've had people in hotel rooms, in robes, like clearly there's nothing else underneath that robe. They are just in bed, hanging out, and we have interrupted something clearly with our court proceedings. So you just never, ever know. But that part's been interesting. Just like the other judges, I think we're absolutely going to continue to use some of the virtual platforms going forward to really make it more efficient for lawyers and not have these large counter call calendars where people are just sitting around for a 5 or 6 minute status conference. We can schedule you on Zoom and make sure that we are being respectful of your time and your client's time, to make sure that you're not billing them an hour, 2 hours for sitting in a courtroom when it's going to be a 5 or 6 minute status conference. So I think we will certainly continue to use this platform to get updates, to do pre-trial conferences. Even I think we're going to continue to use it for discovery disputes. I'm one of those judges who asks lawyers to call him if you have a discovery dispute. I don't allow lawyers to file motions to compel before they've had a conference with the court, an informal conference. And Zoom has been invaluable for that. I can see everybody. We can have a discussion. And it's really interesting. When I get on the Zoom with counsel, everyone gets real reasonable all of a sudden. Like, all of a sudden, there is no dispute. Somehow we have worked it out. I don't know what we were fighting about, Judge. I don't know why we had this hearing. As soon as I get on the call, things start to get worked out. I haven't had a motion to compel filed in my courtroom in 6 years. We have been able to informally get through pretty much every discovery dispute, and I think we'll continue to use Zoom for that purpose.
So I want to combine some of these thoughts. Judge Boulay's lament about the loss of camaraderie, and then all three of your comments about the durability of this remote, some degree of remote work, and ask you, Hill, how do we, knowing particularly, I mean, at Seyfarth, we have felt, you and I each are still at home. Our office is still largely remote. And so there's a lot of ineffables that are associated with in-person interactions that we've lost in our practice. And on the other hand, many colleagues, I'm sure from judicial interns to perhaps to some extent judges themselves and certainly people in private practice, we like the flexibility that this remote work environment has brought to us. So what are your thoughts on how we move forward post-pandemic and take the best of both worlds?
All right. I think there are pros and cons to the pandemic. First of all, this pandemic has been absolutely horrible. It is difficult to comprehend that the number of people who died as a result of COVID-19 in this country. And every day when I watch the morning news, I just find it unbelievable that we've suffered such a tragedy. But in light of it, it has forced some changes. I think that COVID-19 has not only forced the judiciary, but also forced practicing lawyers ahead on the technology curve, maybe 4 or 5 years. Without the pandemic, I think it would have taken 3, 4, 5 years for lawyers to become as competent as they are in using the technology that's available to us now. And probably it would have taken 4 or 5 years for the courts to incorporate the technology into their everyday work, and especially what they call the back office for the courts. I mean, what happens in chambers, what happens behind the curtain. Left to our own devices, our progress into the 21st century would have been a little bit slower. So I think there are some pros there. You know, I'm kind of from the old school. The way I learned to practice law was, you know, when I was in the AG's office, they paired me up with a more senior attorney. And a lot of what I learned just from proximity and watching. Not Harrison Kohler was the attorney I was partnered with, and not Harrison stopping me to tell me things, but me watching Harrison put a case together, how he formed his examination outlines, how he chose what witness to testify to what point. And a lot of it was just passive learning. And the problem I have is that the intangible of the practice, because this is not a job, this is a profession, it's a calling. And that's why we have ethical considerations. And a lot of that doesn't lend itself to virtual learning. I mean, you've got to be in close proximity. You got to see how a more seasoned attorney thinks through a difficult issue, not only from the perspective of what's best for his clients, but what's the right thing to do. And I think we lose a lot of that in this virtual world. So I'm looking forward to getting back in the office. You know, it may not be 5 days a week or 7 days a week. I'm gonna be in the office when the office opens, all the while when the office opens. They're gonna lock me out on holidays because, you know, I love this practice. I mean, this is fun. I've enjoyed this for almost 45 years now. But as I say, that I think that's the substantial downside. It's that intangible that we've lost that I think that is so important that more seasoned attorneys pass on to members who are younger in the practice, that this is not a job. This is a profession, this is a calling, and you can't get that virtually.
So along the lines of the durability of some degree of remote practice in front of the courts, what kinds of new rules are you seeing that you're going to have to implement that perhaps the present rules don't address? Judge Lopez?
That's a great question. I mean, I don't think we're going to see any. We're starting to see rules that deal with the ability to conduct hearings and conduct trials virtually. And I know that those discussions were happening at the legislature this year. That our code did not allow for certain things to happen virtually, and they had to clarify those things. They're attempting to clarify those things. A couple of the other things I saw the legislature trying to do this year that I don't think will pass was the ability to allow courts to hold trials with less than 12 jurors over the objection of attorneys. And so that would certainly help us with backlog issues, certainly help us start up civil trials. You know, one of the problems I have in state court is a lot of my four biggest cases right now that are chomping at the bit to get to trial are four very large, complicated med mal cases. Actually, that's not true. Three of them are med mal cases. One is a terrible trucking accident that resulted in 3 deaths. All of them have lots of experts coming from all over the country. Those are big cases, and those cases want a big jury veneer. They want 36, 42, 50 in the panel so they can start picking juries. That is hard to do in our current circumstance. I mean, we just can't do it. We don't have the space. It would take us 5 days just to pick a jury in that kind of case. And those are exceptions. Those are my 5 biggest cases. That's not the norm. For my smaller cases, you know, if I have a $10,000, $12,000 car wreck and they want 12 in the box, that's hard to do too. It's a lot easier to put 6 in the box and start a jury trial with 6 in the box. That's kind of what the legislature and I think some of the judicial council members were trying to discuss is, can we allow for judges to put 6 in the box over the objection of counsel? And those are the kinds of discussions I know that they've been having. I know Judge Barwick had some thoughts about this yesterday when we were discussing it, so I'm going to turn it over to Judge Barwick.
In terms of new rules that we anticipate, I'd first like to say that I think, again, I'd like to laud our Chief Justice of our state Supreme Court, because they got out fast with rule changes, Uniform Superior Court rule changes that helped so much in terms of video conferencing. The one thing, and I will address what Judge Lopez threw it to me for, but the one thing that everybody needs to keep kind of factor into your decision making as clients or in-house counsel or whatever is that we are still strictly bound by having our proceedings open to the public. And as judges, as individuals, we are governed by professional canons as judges that require us to always have our proceedings open. And so we do that 2 ways. Either I'm sitting in the courtroom and I make a statement at the beginning of each case that I'm in courtroom 8A, our courtroom's open to the public, or I put it on a YouTube live stream, which is intended to last only the length of the hearing and then go away. And you can imagine the technical glitches with that. So just in terms of rules that might impact everybody, just remember it has to be open. And if that openness is achieved through YouTube, you're going to be on YouTube for a little while. In terms of jury numbers, we're just begging everyone to, if we can't do it via state law, or certainly doing by constitutional law, please, 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 if you have to go to court, and I know that's your last option, think about less than 12. And what we were talking about was 12 versus 6. Come up with any number that you can agree to. It doesn't have to be 6. It can be 9. It's just anything less than 12 helps us. Our yield on our very first jury trial was we summoned 300 jurors, 66 came to the courthouse. I think that's fantastic during this. But just think about that. For every juror you pare down, you move way up in priority.
Mm-hmm. Judge Boulay, any prognostications on changes in the federal rules?
You know, I don't know that I have any. I will say, as far as, you know, temporary changes, I think most of your clients that are listening in are probably more interested in the civil side than the criminal side. But to the extent it affects our criminal load and how we can advance that and move to civil cases, being able to do criminal pleas and sentencings with the consent of the defendant remotely has really helped us keep moving those cases, which frees us up on the civil side. And I mentioned earlier remote witnesses, which we can already do under the current federal rules, as I've interpreted them anyway, under Rule 43 with good cause. And I think that standard's even easier to meet when the parties consent to it. As far as other rule changes going forward, I honestly have not done a lot of research on that and thinking about it. So I'll defer to Judge Lopez and Judge Barwick on that.
Well, yesterday when we had a call, we talked a little bit about certainly your own your own courtroom rules. For example, don't do a hearing while on the phone and driving. And so right now, no state or federal court rules get into the minutia on how to present oneself in the courtroom, because I think social opprobrium just works its magic, and people go in the courtroom and realize, oh, maybe I should act appropriately. And yet somehow, as Judge Lopez described, the kinds of things you're seeing on video. So whether or not you anticipate the rules formally changing, what kinds of things have you felt compelled to actually tell people to do or not to do?
Yeah,
that's a good one.
Go ahead.
I would say that this has been an evolving standard, I guess. Initially, I'm not a formal judge. We're serious when we're in the courtroom, but some of the formalism that goes with being in the courtroom, it just doesn't apply to me in my courtroom, and I don't really hold, lawyers to the same standard. So when we started Zooming, I said, look, you can wear business casual. I don't need to see a tie. You can be on your couch. You don't have to be standing at a podium. Just make sure that I can hear you and I can see you, and we go from there. So business casual turned into casual. Casual turned into beach casual. Beach casual turned into pajamas. And this is among lawyers. So we had to start adding things to our notices that said, initially it said business casual. Now it says, please wear pants, please wear shoes, please wear shirts. And that gets to everybody. And again, an ever-evolving standard. Like, we keep adding things as things happen in court. The driving while talking to the court is really just, it happens with litigants. I'm shocked with the number of attorneys who are literally in their car driving their vehicle in the middle of a hearing. That is not helpful to you. It is not helpful to the court. Certainly not helpful to your client's interests. I refuse to have court hearings while someone is driving, so I'll ask them to pull over or we'll reset it if they're not able to. Lawyers who are talking to me while they're walking with their phone. Think about the seasick effect of someone walking and moving the whole time they're talking to you. It is just, again, infuriating. Find a place where you can stop and do your hearing. I don't know if y'all saw, there was a case out of California where it was a routine speeding trial. It was with the defendant was a surgeon and he was in surgery.
Yeah.
And he tells the court, go ahead, I can participate. As I'm cutting into somebody, I'm in, keep going. And the judge says, no, I'm not going to have, you're clearly busy. Please pay attention to what you're doing. So it's an ever-evolving standard and things happen. I think we're all getting used to the virtual world. But I think if you're an attorney and you're appearing in a court, just basic things like, please make sure you have a stable internet connection. Make sure that we can hear you. Make sure we can see you. Make sure you're not in a moving vehicle or you're walking or you're standing outside next to a freeway where there's a lot of background noise. And these are all things that have happened that I've had to say, counsel, please find somewhere else to go. Next to a freeway is not a place to conduct a hearing because I can't hear you. And it certainly impacts there. I did a bench trial with a lawyer that was standing outside next to a roadway, and we could not hear him. And it was detrimental to his client and to his client's interests. So just basic common sense things like that I think will help you be effective.
Judges Boulay or Barwick, anything to add on new rules that you have implemented?
I think Judge Lopez did a wonderful job.
So dovetailing that topic, one other line of inquiry to switch us up a little bit. What kinds of things do you see lawyers do that really serve their clients' interests or really don't serve their clients' interests, whether it's during the pandemic or pre or post pandemic, and setting aside, of course, Judge Lopez's, get real and be a civilized human being on the video? Judge Boulay?
Sure. Well, I've been just continually impressed, both in my time on the DeKalb Superior Court and here in U.S. District Court, just about the caliber of the lawyers that have appeared before me. Certainly there have been a few bad apples and things I can criticize, but I think for the most part, attorneys are doing an excellent job. And like both Judge Lopez and I mentioned earlier, recognizing that so many people are juggling their work and, their 8-year-old that's taking remote classes. I've been really impressed how both the judiciary and the bar has ramped up and reacted to this. If I were going to just give a few tips or things where I have seen some negativity, I would have litigants focus on their civility to each other when neither Judge Lopez, Judge Barwick, or Judge Boulay are on the email string or in the deposition or in the room, because, as Judge Lopez noted, people are always very polite and kind to each other when we're on the line or on the Zoom conference with them. But I often see, I have the same policy as Judge Lopez about, don't file a motion to compel until you've, filed a joint statement, tell me what's going on, and we can have a call about it. But I continually see emails back and forth where attorneys are very, very rude and impolite to each other. That was one thing back when I was practicing law that I couldn't stand. I'd sometimes realize who was on the other side and, knew their tactics and would just sigh about it. So I would really encourage folks to, act the way they act in front of us all the time against opposing counsel. My view is you do your client a good service by doing that. I would also say on discovery, if you need more time, let the court know in advance that you're having some trouble. I think most judges are reasonable. I like to think I'm fairly reasonable, but I do like to know in advance that you're having trouble, as opposed to, a month or 2 months after the discovery deadline that you need to open it back up. So I think that would be one of the main things.
Want to go next? I just have one purpose of being on this call, and I am so thrilled that he'll ask me, because it's just one message to in-house counsel and to clients, is that this is an incredibly sensitive, weird time. And I use the sword shield. It's obvious to see how, don't use COVID as a sword. If you're the defendant and you are deliberately delaying and you are using COVID as an excuse because that's costing the other side money, we know. Everybody knows what you're doing. And if you're ever going to ask us for attorney's fees, we know what you're doing. But the other thing as a shield is, this is a really strange time, because if you're going to come before us and say, I couldn't do it because of COVID, we are all working ourselves, not working ourselves to death, but people are working themselves trying to get out of this. We have constant meetings about how to have jury trials. Our IT department look like you would expect somebody to look after 8 years as president. I mean, they're old, they're underfed and underloved. And so we are working as hard as we can. Do not come in here and tell us we can't take that deposition because of COVID. This is not the time to use it as a sword or shield. Thank you.
Judge Lopez?
So let me first start by complimenting Hill. Hill, to this day, is probably still the best trial attorney I've ever seen, worked for. I clerked at a federal district court. I've been on the bench 11 years, and I've had the honor of trying several cases with Hill in my time. And to his earlier point, the amount of knowledge I gained just by being in his proximity, by being next to him and carrying his briefcase to court every time we went to trial. It made me a better lawyer and it made me a better judge. But still, to this day, 11 years on the bench, I've presided over hundreds of cases. Hill is probably still the best trial lawyer I've ever seen. So, Seyfarth clients, you're very lucky that you have probably one of the preeminent trial lawyers in the state and probably in the country sitting, right there in your offices. But that is all to say that the things that I saw Hill do well are the things that I look for in the lawyers that are the most effective in front of me. And I'll just very quickly tell you this story. I tell lawyers all the time, frame the issues you want the court to focus on, frame the issues you want the jury to focus on, and don't spend so much time just responding to what the other side said. Don't let the other side frame it for you. And there's a lot, lawyers spend a lot of time this tit for tat. They said this, so I have to respond immediately to what they said. And you sort of lose sight of the fact that you've got a story to tell and focusing the jury and focusing the trial judge on that story and not just responding to what the other side said. And the best illustration of that is a case I had. It's a small misdemeanor case, but it's still the best illustration I have to date. And it was a pro se defendant. My pro se defendant was a frequent flyer in our courtroom. He had 5 or 6 or 7 shoplifting cases, and the trial he went to trial on was the shoplifting case against Publix. He has shoplifted at Publix many times. They know him extremely well. And the minute he walked into the Publix, every single camera in the building was trained on him. The risk manager comes out of his office the minute he walked into the Publix because they've seen him before. The risk manager follows the defendant to the meat department, where the defendant promptly starts taking steaks and stuffing it down his pants. He has about 12 steaks down his pants. He walks to the front, waddles to the front door because he can barely walk, and crosses the threshold. He has now committed the offense of shoplifting. They immediately stop him, bring him back inside, take all the steaks out of his pants. He makes a run for it. They tackle him, and they call the cops. So now he is representing himself. We've got multiple eyewitnesses that saw him do what he's been accused of. The solicitor thinks slam dunk case. There's no defense lawyer. It's pro se. Not even going to prepare for this case. I've got this. So the solicitor does what he does. He starts putting up his witnesses. They put up the risk manager, and the risk manager goes through this whole story about how we've seen him before, we know him, we watched him, we videotaped him, and gives this whole elaborate story about how he watched him do what he's been accused of. The defendant gets up on cross and asks 1, 2, maybe 3 questions, and they were essentially this. You guys have cameras in the store? Yes. Where's the tape at? Where's the video? And the manager says, well, we taped over it. We don't have the copy of the video. Thank you. And he sits down. He doesn't focus on anything else. Police officer takes a stand, tells the whole story about he's called. He shows up. They tell him he watched the video. He saw what was going on. He takes all the statements from the witnesses. He arrests the defendant, takes him to jail. The defendant gets up on cross and says, you didn't take me to jail. Why'd you take me? And the officer says, you're right. I took you to Grady. I took you to Grady Hospital. You were hurt. And that's where I took you. Thank you. Sits down. He's asked 4 questions at this whole trial. He gets up on closing. He says, ladies and gentlemen, where's that video at? They're hiding something. Thank you. And he sits down. 15 minutes later, he was acquitted. He had a story to tell. He says his whole thing is they're hiding something from you. They hurt me. They took me to the hospital, and they don't want to show you the truth. And the jury focused on that. They didn't focus on any of the other things. So I tell lawyers all the time, all that fancy lawyering sometimes is not as critical as getting the jury and getting the court focused on your issues, on your story. And sometimes you kind of have to disregard some of the things the other side says. Not always. Obviously, as lawyers, some things have to be responded to. But you got to make those determinations. And the best lawyers are the ones who can sort of cut through the noise and get the court and the jury focused on those issues.
So with that wonderful tee-up, I want to turn to Hill. But before that, I need to say the CLE code. And so take it down because we're not going to repeat it because you want your professionalism and possibly your ethics CLE. It is SS, as in Seyfarth Shaw, 7422. SS 7422. And with that, Hill, take it away. What Give us just your top 3 nuggets for what best serves clients' interests, particularly interacting with the judiciary.
It's been my experience that the first thing you need to do is you and your client have to agree on what the true issue for resolution is. Oftentimes when clients come to me, they come to me because it's the symptomatic manifestations of a problem that drive them in to talk to me, because they're dealing with the everyday issues. They're trying to run a business. And when I talk to them and I understand what their current issues are, their current problems, if you look deeper, you find the genesis for those problems. And so in a conversation with client, the first thing I try to do is come to an understanding of what is the definition of success. Do you want to simply resolve the current issues, the symptomatic manifestations of the problem, and then you come back to me in about 4 years and we're going to do it again? Or do you want to solve those and the underlying problem? And, you know, once you come to an agreement on whatever the client wants, because the client is business driven, once we come to an agreement, we have to decide what is success. And I've had clients tell me, if you keep the verdict below $50 million, that'll be success. Okay. And then we get to trial. And then we're after the first week and a half of trial, the client tells me, well, we're going to win this case. No, wait a minute. You're redefining the definition of success. Success was keep it below $50 million. So in dealing with a client, the thing I want to do is I want to serve my client's interest. I have to understand what the client's interest is, and we have to agree on what the definition of success is. And I try to explain to my clients, my job is to get you where you need to be as quickly as possible, as efficiently as possible, and as economically as possible. And sometimes I'm not going to want to do what you ask me to do, because my focus is on what is necessary for my audience to understand the issue. And my audience is the judge, especially in pretrial. My audience is not the client. The client may be focused on the impact on worker morale, but worker morale is not relevant to this motion I'm filing before the court. So that motion may not have in it some of the speaking points the client wants, but as Judge Lopez pointed out, I don't need that collateral. I need to define the issue for resolution on this particular motion, and I am speaking to my audience on this position, which is the judge. Now, once we get through pretrial and a jury is in the box, the jury is my audience, not the judge. The judge is calling balls and strikes and making sure we stay inside the bounds. But I have got to persuade that jury. My language changes, my jargon changes, no $1.25 words. I'm speaking in 25-cent words, and my presentation to the jury has to be imagery. The jury has to do more than just hear what I say. My language has to be imagery. They've got to see it. And I've got to give them things they can hold on to, sound bites, nuggets. And the jury is not going to remember everything every witness said, but if I can get that jury to remember that I impeached that witness 5 times, they won't remember the testimony, but they'll remember I got him 5 times. Every time there was a successful impeachment, I end by saying, thank you very much. And after a while, when the jury hears me say, thank you very much, they go, he got him again. So in trying to serve my client, just as Judge Lopez said, I am focused on trying to get my client to resolution as quickly as possible, as economically as possible, and as efficiently as possible. Oftentimes, the slowest part in the development of a trial is in discovery. And I think that in that regard, the use of technology is going to help us move discovery along. We can get discovery disputes resolved. And I think doing them virtually with video is a lot better than trying to do it over the telephone. So I think that in that regard, it's going to help us move cases faster. If we move cases faster, we touch them less often, it costs the client less money.
All right. With that, we are at our time.
I got to correct Hill real quick. Hill, the conversation, because I was in the room, the conversation was the definition of success in this case is under 100 million, as I recall, that case. And then they changed it to 50 million after the first week of trial. And then that number kept going down. We got to keep it up to 20 million. And eventually, by the end of the trial, they said it needs to be a defense verdict or this has been a failure. So I was there for that trial, so I know well how those conversations happened.
You got
Judge
a very
Lopez,
good
you can't
memory,
leave us
Judge.
hanging. What happened?
It was two related cases. One was a full defense verdict, and one was under 20 million.
I was trying two mesothelioma cases simultaneously to the same jury, two totally different cases,
Wow.
but to the same
That's
jury
efficient.
one time in New York Supreme Court.
Well, thank you all very much. We want to respect your time and our attendees' time. This has been terrific, and we had one pending question. I'll circulate it by email, and perhaps we can get a written response out. But again, Judges Lopez, Barwick, and Boulay, thank you so much. And Hill, thank you.
All right.
Thanks for having me.
Thank you.
Thank you, judges.
Thanks for having us.
Thank you, Rebecca.
Take care, everyone.